I hope you can also see the interpreter and the presentation. I thank you all for coming again, regrouping today on my request after a day. I really appreciate the effort that all the participants are giving and are committed to the discussion that we would like to take this forward ahead. Without any more delay, let me quickly run through the presentation and then we can open this discussion for everybody to give their comments, their viewpoints, and we can take this interaction further. Let's move to the next slide, please.
Somebody should explain also.
The directions of the Honorable Court in a judgment way back in 15th December 27, where they had identified 11 action points pursuant to the RPW Act and the Accessible India Campaign for Compliance. These action points pertain to accessibility to all government buildings, offices, all transportation carriers like railways, airports, buses, and then they also spoke about the ICT ecosystem. They referred to governmental websites and portals. The Union of India, all the state governments, and the UT administrations were directed to file their compliance affidavits within 3 months. Most of the states and union territories, however, felt a little delayed in the required information and they failed to file their compliance affidavits. Thereby, on the 29th of November, cutting the long story short, the NALSA was directed to submit a report by the Honorable Supreme Court on the steps taken so far and the requirement and the status of accessibility in the entire country. I now read what the Honorable Court directed on their 8th November 2024 ruling. It said, several of the guidelines prescribed in Rule 15 appear to be recommendatory guidelines under the garb of mandatory rules. Rule 15.1 is thus ultra-virus, the scheme and the legislative intent of the Act which creates a mechanism for mandatory compliance. Creating a minimum flow of accessibility cannot be left to the altar of progressive realization. Next. They also directed that it is important now to delineate mandatory rules that are required by Section 40 within a period of 3 months from the date of this judgment. This exercise would involve segregating non-negotiable rules from expansive guidelines which are already prescribed under the rules. The Union government was directed to conduct this exercise in consultation with all stakeholders. Today's meeting is one such consultation. It is to be clarified that the progressive compliance with the standards existing in the Rule 15.1 listed and the progress towards the targets of Accessible India campaign are to continue unabated. It was also directed that once these mandatory rules are prescribed, the Union of India, the state governments, the UT administrations are directed to ensure that the consequences prescribed in the different sections 44, 45, 46, 89 of the Act, including holding back of completion certificates for new buildings, imposition of fines in case these are not fulfilling accessibility requirements, are to be implemented in the case of non-compliance with Rule 15. The Honorable Court also laid down these 4 broad principles of accessibility which should be considered while all the authorities are carrying out the exercise. The concept of universal design, a comprehensive inclusion which is required across disabilities, use of assistive technology and its integration, and continuous and ongoing stakeholder consultations. I also want to, for everybody's benefit, to read out the different sections that are applicable to today's discussion. Section 40 states, the central government shall, in consultation with the Chief Commissioner, formulate rules for persons with disabilities, laying down standards of accessibility related to physical environment, transportation, information and communications, including appropriate technologies and systems and other facilities and services provided to the public in urban and rural areas. Under Section 41, hello? Yes, please. Does somebody want to say something? Section 41 states that the appropriate government shall take suitable measures to ensure that there are facilities for people with disabilities at major transportation areas like bus stops, railway stations, airports, where there shall be conformity to accessibility standards related to parking spaces, toilets, ticketing counters, ticketing machines. The access to all modes of transport should conform to the design standards, including retrofitting of all modes of transport wherever technically feasible, and accessible roads to address these mobility requirements. The appropriate government shall also develop scheme programs to promote the personal mobility of persons with disabilities at affordable costs. Section 42 of the DEPwD Act 2016 also states that the government shall take measures to ensure that all contents that are available on audio, print, electronic media are in accessible format. Persons with disabilities have access to electronic media by providing audio description, sign language interpretation, and closed captioning. Electronic goods and equipment which are meant for everyday use are available in universal design. The Rule 15 of the aforementioned rules of accessibility states that every establishment shall comply with the following standards relating to physical environment, transport and information, and community technology, and these are to be notified as standards under these rules, and that different ministries and departments should ensure compliance of these standards of accessibility specified under this rule, and they can do so either through their domain regulators or otherwise. The Central Advisory Board on Disability also said that in the exercise of powers conferred by subsection 1(2) of section 60, the department, while its notification when constituting the Central Advisory Board on Disability, said in its deliberation suggested the department to formulate sector-specific accessibility standards/guidelines with 20 central government ministries and departments who are also the part of the board. This is the last point of the presentation which I want to mention, that out of the 20 ministries and departments, 13 ministries and departments have specified their accessibility standards. 3 ministries and departments have adopted the other notified guidelines, and there are some 3 or 4 ministries whose guidelines/standards are in their draft mode and are yet to be finally notified. These slides that are enlisting the different standards read are for respectively Ministry of Housing and Urban Affairs regarding harmonized guidelines and space standards for universal accessibility, the Bureau of Indian Standards under Department of Consumer Affairs for accessibility for the ICT products and services. Ministry of Culture has their culture sector specified harmonized standards. Department of Sports has issued and notified guidelines on accessible sports complexes and residential facilities for sports persons with disabilities. The Ministry of Civil Aviation have issued accessibility standards and guidelines to be followed at international and domestic airports. The Ministry of Health and Family Welfare has accessibility standards for their healthcare institutions. Ministry of Rural Development has issued specified harmonized accessibility standards and guidelines. The Department of Drinking Water and Sanitation has accessible inclusive pipe water supply guidelines to access population which suffer or are challenged with certain issues, and accessibility standards for community toilets in rural areas. Ministry of Port, Shipping and Waterways, accessibility standard in port sector. Ministry of Railways has issued guidelines regarding accessibility of railway stations and facilities at stations. Ministry of Home Affairs has accessibility standards and guidelines for specific built infrastructure and associated services vis-a-vis police stations, prisons, and disaster mitigation centers. There are 3 more that have been notified. Department of School Education and Literacy have accessibility codes for education institutions. The Department of Higher Education has accessibility guidelines and standards for higher education institutions and universities. And Department of Financial Services has formulated their accessibility standard guidelines for banking sector. The 3 ministries and departments that have adopted the guidelines and standards of different ministries are the Department of Telecommunication with respect to ICT products and services, Department of Law and Justice that have adopted Ministry of Housing and Urban Affairs harmonized guidelines and BIS standards for ICT products, and Ministry of Electronics and Information Technology who have adopted the BIS standards accessibility for ICT products and services. I'll end the presentation here, and I do look forward to now taking in your comments on telling us about how we can take this direction of the Honorable Supreme Court forward. What is your take on how we can ensure enforceability of these standards and the use of fines wherever there is non-compliance? I now open this meeting for discussion. I request everyone to either raise their hand or devise a way in which we can move this conversation smoothly from one speaker to the other. Thank you.
Madam Chair, can I?
Yes, please.
Madam Chair, 3 points that I wish to make, and I will start from point number 1, which Supreme Court has highlighted, stakeholder consultations. Madam Chair, probably you would know that there are, in visual disability field, there are three national organizations. There are 3 national organizations. One is mine. I am represented in this consultation, but 2 are missing, who are very important stakeholders, and they should have been invited. AICB and National Association for the Blind. They are national organizations. They have all 3 of us have large networks of end users, of the consumers who are blind and low vision. Second point that I wish to make, and therefore I request you to add to this list these representatives of these organizations for further consultations. B, second point. I have gone through some of the accessibility standards devised and notified by certain ministries and their guidelines. In all these guidelines and standards, we have tried to emphasize only on the design aspect. We have not tried to address the issues other than we have not tried to address the issues of the disabilities, sensory disabled people who are having sensory disabilities like visual impairment, hearing impairment in these guidelines. For instance, when we provide certain services, take for instance the railway, the issue of the human assistance free of charge at railway stations is an issue which High Court of Delhi is grappling with. I am acting as amicus in that issue. And railways are still saying that it is not possible. One would ask, is it not a requirement, accessibility requirement? Should it not go in these standards? Now, similarly, your own national scholarship portal, they have recently introduced in this very academic session face recognition system for verification of applicant for this scholarship. Imagine a situation, and we had been grappling with it. There are cases of blind persons who do not have cornea. You can't take their live picture of eye, and therefore should they be excluded? When we are providing, what I mean to say, when you are providing procedures and putting in place the mechanisms, you don't consider the implications of accessibility for certain disability groups. So this needs to be factored in the rule itself, that it is not only the infrastructure, creation of infrastructure or design of infrastructure, but is also the procedures and mechanisms, particularly in respect of the services to be provided, including but not limited to transportation, road, etc. And in your presentation, madam, you have not referred to section 46, and this section 46 is very important because it also includes the private service providers. I may read for the benefit of all of us: time limit for accessibility by service providers. Section 46, the service providers, whether government or private, shall provide services in accordance with the rules on accessibility formulated by the central government under section 40 within a period of 2 years from the date of notification of such rules. So, in your entire presentation, the emphasis was on government. Are we ignoring section 46? The private players have also to be brought in. Are also to be brought in. So, these are my few thoughts for the present.
Thank you. I would now request first Mr. T.D. Dharyal, and I would also mention that after that we will take Mr. Jayant Singh Raghav and then Dr. Indumati Rao. We will follow that serial as for the next three speakers. Thank you. Request
and after that, if I may be given an opportunity after that.
After that, we will take you on, Rahul. Thank you.
Thank you.
Good afternoon, everybody. Thank you, madam. Rudaji said 3 organizations. I am representing National Association for the Blind, Delhi. I have 3 issues. Let us confine to the issues contained in the directions of Honorable Supreme Court. It's basically on Rule 15 that it has to be mandatory. So it compromises with the mandatory nature of the provisions of RPWD Act. The accessibility aspect, even if Section 46 were not there, is mandatory for all public places, and the public places have been defined as any place which is open to public, which means it could be government building, it could be any service provided by a private organization which is open to public. It could be, let me say, a delivery shop, a barber shop, a cinema hall, and everything. So accessibility provision in the Act is it encompasses everything that is called public place, which has been defined. So everybody knows that. Now, therefore, private sector has to also do it. Every individual has to do it who is providing the service. Now, there are two aspects there are certain common issues, common services, facilities that need to be made accessible. That those barriers, they have common barriers which need to be removed. Everybody, every ministry, every organization need not, do that again. That repetition is not required. We can identify the common facilities or common barriers and the standard that central government would be Ministry of UD or our AIS, not only for physical built environment, but also for ICT and others, all these communication and all this, those facilities. And also include the issues, barriers for people with disabilities, very disabilities, other disabilities, say, for example, intellectually disabled, persons with autism, persons with, say, very blood disorder. We have not given a thought to it, whether they have any barriers. So those barriers, common barriers, whether it is in this ministry, whether it is with the private sector, whether it is in a shop or anywhere, whether it is rural areas or urban areas, these things are common. Say, for example, the measurements of, the ramp, or the width of the door, all these things, so these are common. So everybody need not see. Now then, specific to a particular service. Barriers, second point is barriers specific to the barriers specific to a particular service. Now, these may not be applicable to all, but a few or many of you. So identify those barriers, those facilities for which we do not have the standards, mandatory standards. Then third is the individual, that is individual requirement, which is reasonable accommodation. It is not that we have provided these facilities, therefore it would be, everybody would be able to access it. We can, so therefore we should, my suggestion is identify common barriers and common facilities. Identify those which are specific to different services, which will be evolving, which will depend upon the technological development and so on and so forth, as the services, widest. So therefore, there should be uniformity of standards for different facilities, and to remove those barriers for varied disabilities, not 1, 2, 3, 4, all disabilities you should think of. And therefore, we should invite in this stakeholder meeting the representatives, I would say primary stakeholders, that is those who are living with those disabilities, all these 21, or the organization working for them, and I would say, and organization working for them. So that is what I I say three things: as individual accommodation, reasonable accommodation, then common barriers and common.
Yes, thank you, Mr. Daryal. Because of paucity of time, I again request all speakers to please limit yourself to about 2 to 3 minutes. If there is some point that an earlier speaker has already mentioned, I would request you to only focus on new points. We move on to Mr. Jayant Raghav, please. Thereafter, it's Dr. Indumati and then Rahul. I will mention the other names. I have listed it out beyond Rahul also after the next speaker. Please.
Jayant Raghavji.
So Jayant Raghav, are you on?
Yeah. Good evening, ma'am. Am I audible to everyone?
Yes, you're audible. Just 2 minutes, please.
Yeah, sure, ma'am. I will just finish in a minute or so. So, ma'am, I'm just making a point which is very important, and before we proceed further towards the rules and everything, I just want to emphasize on the point that we see that on the section 40 or the provision under section 40. So it says, ma'am, it's very important to have the chief commissioner that since we've not been having since long time, and without the having of the chief commissioner, the rules cannot be framed, because it clearly says that the rules can only be framed in consultation with the chief commissioner. So my emphasis lies upon, once if this practice is done without the chief commissioner, again the same practice needs to be done again, because it would be again in the violation of the provision of section 40. So I'm just making this point that having the chief commissioner as soon as possible or at the earliest possible before we finalize the rules must be in place, and the consultation must be done with the chief commissioner, because that's a mandate of the act, and that's the point that I had to make. And that's all, ma'am. Thank you. Thank you so much, ma'am.
Thank you. Thank you so much for being so precise. We move on to Dr. Indumati. Dr. Indumati. Dr. Indumati?
Yes. Can you hear me?
Yeah. Yes, now we can. If you can go closer to the mic, it will be even better.
I to three vital points. Honorable Supreme Court has specifically mentioned access to this. That thought was that will cover both inclusivity, equitability, and we need to really look into developing, because based on those like design is universal and whether it is equitable and whether it is inclusive. I wish to share a guideline from which was developed about 4 years ago, keeping all dimensions of the school. Say that disability or visual disability. It looked at all aspects of all these 21 types of disabilities, and the guidelines were prepared. And similarly, from AICTE, a similar guideline was prepared for all schools and colleges. The guidelines are based on inclusivity and equitability. My third request is, unless we look at entire equitability at district level, block level, in rural tribal India, the user will not enjoy the fruits of accessibility. So for that we need to develop guidelines, accessibility which is friendly to Indian ecosystem, and that needs forming sessions and a group to work on that, because inclusivity at global level and accessibility at India grassroots level, they're totally different. we can't apply the same, so we need to come out with tailor-made solutions, and that is very important. My last request is, finally, it is money. So where does the money come from? Here I wish to bring your attention to the government of Karnataka, which has come out with a guideline to all the panchayats to reserve 5% of the development budget, which includes developing their district as a accessible district. So I don't see similar orders and guidelines in any other state. As far as my knowledge is concerned, I don't know if states have developed their own guidelines. So 5% of development budget is a lot of money that is available at the district level with specific guidelines on universal accessible design, including universal design of learning. That we will go a long way. So we need the Indian standards of accessibility, not just following the global standards. Global standards are there, but Indian terrain, Indian culture, Indian diversity is quite different. We need to really have a deeper look into understanding these aspects. Dhanyavad.
Regarding discussion on Rajiv Raturi case judgment, activate press space bar. Meeting with stakeholders regarding discussion on Rajiv Raturi case judgment dialogue. Meeting with
We move on. Thank you. We move on to Rahul. After Rahul, we'll take Nipun Malhotra, Professor Sanjay Jain, Mr. Sudeep Goyal. Thank you. Please, I request everybody to be take not more than 2 minutes, please. Please be precise. Thank you.
Rahul, unmute yourself, Rahul.
Sorry, can you hear me now?
Yes, now you.
Madam Chair, I welcome the opportunity to share my remarks, and by the clock I won't take more than 2 minutes. I'd like to make 6 specific points. Point number 1, as the court judgment in Raturi points out, even as we are working towards formulating non-negotiable parameters in each sector, compliance with the existing guidelines as currently framed on a progressive basis, as well as the Accessible India campaign targets, must continue unabated. I want to underscore this point so that it doesn't so happen that while framing the non-negotiable, we let the rest of the parameters be given a go by. Point number 2, I would like to say that as we are talking about withholding completion certificates in cases of non-compliance with non-negotiable parameters, similarly, we need to evolve similar compelling mechanisms, compelling devices in each sector, which would ensure that at the threshold, compliance with those non-negotiable parameters is checked. E.g., in the context of buses, not issuing a fitness certificate unless a maximum floor height and ramp requirements are met. Now, for sectors where you need a prior clearance, like in a building where you need an occupancy or completion certificate, this check is much easier. But for, say, a website or a cab aggregator or an OTT provider, where you don't want the government to be involved due to prior censorship-related concerns, how do we check for accessibility there is something we would need to look at, and perhaps asking the service provider for an undertaking and an annual report on compliance and penalization in cases of non-compliance may be one way forward. Third, we need to ensure that not only are we setting out these non-negotiable parameters, but also urging relevant regulators across the board to carry them out in their respective regulations. E.g., just having the harmonized guidelines and their non-negotiable parameters will not do. They need to be harmonized with the local municipal bylaws and rules, and the center has an important role in persuading various stakeholders in this regard. Fourth, we need to ensure, in line with section 45(2), which talks about prioritizing certain places, that places like hospitals, schools, bus stops, etc., and shopping centers, where the footfall is high, are prioritized when we come to these non-negotiable parameters. Number 5, in each ministry, an accessibility grievance officer should be appointed who can ensure compliance with those non-negotiable parameters. And lastly, when we talk about fines, we need to ensure that these are effective, proportionate, and dissuasive. Here, two models are permissible. One, if we are continuing to work within the Section 89 framework, then we need to lay out some parameters to ensure that the fines are linked with the nature of the entity. You can't have the same fine for a Google or Microsoft that you have for a one-time violator. And for those who are continuing to violate, it must be a continuing offense. For every day of violation, the fine must be imposed. And the second possibility to explore is a legislative amendment where the quantum of the fine is also increased. I don't know what the appetite of the government is in this regard, but I'm just laying that out that that aspect also needs to be thought about. Thanks very much.
Thank you. We move on to Nipun Malhotra. Thereafter, it's Professor Sanjay Jain, Mr. Sudeep Goyal, and then it is Malika Arjun. If I'm not calling anybody's name, it's because it's a longer list. I will take your name. Don't worry.
Right. Thank you so much for giving me the time, ma'am. I basically have 2 points, and I'll be very brief. My first point really is that, to be very honest, I don't think a lot of the ministries really understand disability. Rahul has made the point of having a nodal officer, but I think that's more long term. And at least in these 3 months, I think both the Department of Empowerment of Persons with Disabilities and the disability community should take a lead with other ministries as well when they are developing their accessibility standards. And to be very honest, a lot of the accessibility standards will be very common because the gradient of a ramp is the same whether it's shipping or sports or urban affairs, or the way an accessibility toilet is built is the same in that sense. So I think the Ministry of Social Justice Empowerment could perhaps, along with the community, come up with some minimum standards that every ministry has to follow, and the ministries can come up with more standards that are specific to those ministries while communicating with the disability sector. Secondly, I think within these 3 months, it would be great to actually also create a checklist by the Ministry of policies, laws, and bylaws that intersect with this, because just having Rule 15 as mandatory but not changing a building bylaw in a state will be futile, because the government officer will go to give a government completion certificate might not even know the Rule 15 existence because they just look at what the building bylaws in that particular state are. So I think we'd have to work together with all state governments to ensure all laws are harmonized along with Rule 15 in whichever way it comes down. Thank you.
Thank you. Appreciate your precise comments. Professor Sanjay Jain.
Thank you, Chairperson. I will not take much time. However, I would like to draw attention to broad points which have been missed, I think. Do we have a focal point, national focal point for enforcement of RPWD Act? And in absence of focal point like CCPD, can we really make progress? I mean, when you see government continuously flouting the directions of the court and not taking any interest in implementing the judgments of the judgments, why we should believe government? The government would do something positive in the next 3 months. I'm very blunt, but that is my first point. And my second point is Section 45 Clause 2, which brings in appropriate governments. It's not only central government, although central government is under onus to provide for accessibility standards. The primary responsibility, I think, is on the appropriate government, and therefore any consultation must also involve, as Ruptati very rightly said, it should be inclusive. It should not only involve disabled, but non-disabled stakeholders who are under onus to implement RPWD Act. And I think we don't have representatives, if I'm right, from the sector. And although I agree with Mr. Dharyal that public is defined very broadly, still we cannot conflict the important distinction between public and private. And at a time when government is withdrawing fast from different sectors, I mean, it is important that Section 46 gets more teeth and private sector is also brought in. And I don't see anybody from private sector being asked to join this meeting. So I think last point, I don't think that Supreme Court judgment is asking us to sectorally identify minimum post. The judgment is very clear: minimum floor of accessibility. So first we have to identify minimum floor of accessibility, and then that minimum floor of accessibility has to be written into Rule 15. We need to also take into account the translation between the standards and guidelines. The word guidelines is not there in section 14, which has been brought in under Rule 15. So these are technicalities for which I think we need an expert group. But as a born optimist, nevertheless, I hope that something magical will happen in the next 3 months. Thank you.
Thank you. We will now hear Mr. Sudeep Goyal, then Mallika Arjun, and then Dr. Smriti.
नमस्कार मैम जी नमस्कार सुदीप गोयल मेरे 2 पॉइंट यह रहेगा मैम एक्चुअली जो सुप्रीम कोर्ट ने ये बोला है कि सारी गाइडलाइंस को अल्ट्रा वायरस करके और मिनिमम नॉन नेगोशिएबल स्टैंडर्ड बनाए जाए तो उसके अंदर में एनबीसी जो नेशनल बिल्डिंग कोड 2016 है जो अभी रिवीजन में भी है उसके अंदर में सेक्शन 30 और एनेक्सर भी है जो एक्सेसिबिलिटी के प्रोविजंस को स्पेसिफिकली देखते हैं। साथ में अपने मॉडल डीसीआर जो है डेवलपमेंट कंट्रोल रेगुलेशंस है बीआईएस ने अभी निकाले हैं 2024 के अंदर में उसमें भी एक्सेसिबिलिटी का पॉइंट आता है। तो हमें री इन्वेंट फील करने की जरूरत नहीं है। अगर हम लोग उन्हीं के एक्सेसिबिलिटी स्टैंडर्ड को देख लेते हैं और अगर वो फाइन ट्यून कर लेते हैं अगर उसमें कोई इश्यूज हैं तो आई थिंक दैट वुड बी मच बेटर बिकॉज जितने भी बिल्ट एनवायरमेंट के अंदर में आपके इंजीनियर्स हैं ठेकेदार हैं ये सभी लोग जो है एनबीसी को ज्यादा मानते हैं। एनबीसी ही कंप्लीशन सर्टिफिकेट देता है तो दैट वुड बी बेयर मिनिमम जो है स्टैंडर्ड इसके नॉन नेगोशिएबल हो सकते हैं अगर हम लोग एनबीसी मॉडल जो डीसीआर बीआईएस ने अभी नोटिफाई किया है उसके अंदर में जो एक्सेसिबिलिटी की प्रोविजन है उनको हम लोग देख लें उसमें अगर कोई फाइन ट्यूनिंग करने की जरूरत है तो वो कर लेते हैं। सेकंड पॉइंट जो है मैं हम लोग कहना चाहेंगे कि जो पर्सन विद डिसेबिलिटीज के लिए एक्सेसिबिलिटी के प्रोविजन अभी जो गाइडलाइंस में है वो मोर और लेस जो है पर्सन विद फिजिकल डिसेबिलिटीज विद इम्पेयरमेंट इम्पेयरमेंट के लिए तो थोड़े से हैं बट न्यूरो डाइवर्स पॉपुलेशन के लिए नहीं है पर्सन विद इंटेलेक्चुअल डिसेबिलिटीज ऑटिज्म के लिए। तो वहां पर हमें जरूर एक बार एनबीसी के अंदर में भी और नई गाइडलाइन जो बनाएंगे उसके अंदर में भी जरूरत है कि कुछ चीजों को इसमें डाला जाए कि सिंपल लैंग्वेज हो सेंसरी ओवरलोड जो है नहीं हो वहाँ पर क्लाउड स्पेसेस नहीं हो लाइटिंग नहीं हो जो बेसिक चीजें होती हैं अपना जैसे कि वो नहीं कर सके। आईसीटी के अंदर में भी लेवलिंग में भी जैसे अभी हम लोगों ने नोट किया है कि लेवल प्रोडक्ट के अंदर में ट्रेल में आ रही है उनके प्रोडक्ट का नाम या उनकी डिटेल्स ऑफ बिल के अंदर में है। ऐसा ही अगर हम लोग आईसीटी का यूज करके मान लीजिए क्यूआर कोड फॉर एग्जांपल क्यूआर कोड अगर वहाँ पर एक लगा दे जो कि पर्सन विद इंटेलेक्चुअल डिसेबिलिटी उसको स्कैन करते हैं तो वो क्यूआर कोड बताता है कि हाँ ये प्रोडक्ट ये है इतनी मेजरमेंट है इसकी इतनी कॉस्ट है बेसिक इन्फॉर्मेशन वहां पर आ जाए क्योंकि पर्सन विद इंटेलेक्चुअल डिसेबिलिटीज मोर और लेस जो है वो पढ़ने में उनको थोड़ी सी दिक्कत रहती है काफी केसेस के अंदर में। क्यूआर कोड के माध्यम से या और इस तरह के टेक्नोलॉजिकल इनोवेशन के माध्यम से हम लोग जो है अगर लेबलिंग प्रोडक्ट लेबलिंग आईसीटी के अंदर में भी अगर उनको हम लोग इन्फॉर्मेशन दे सकते हैं तो इसके ऊपर भी हमें एक्सप्लोर करना चाहिए। बाकी सारी चीजें तो क्वाइट केसेस हैं आपके उसमें एक चीज और इसमें रहेगा कि पर्सन विद इंटेलेक्चुअल डिसेबिलिटीज साथ में खास करके उनके जो केयर गिवर्स हैं पेरेंट्स हैं वो हमेशा मतलब काफी केसेस में सपोर्ट करते हैं उनको। तो जैसे अगर हम लोग प्रायोरिटी सीटिंग की बात कर रहे हैं या प्रायोरिटी एक्सेस की बात कर रहे हैं बिल्डिंग के अंदर में तो हमें केयर गिवर्स के लिए भी देखना चाहिए। एयरपोर्ट के अंदर अगर हम लोगों ने या कहीं पर भी उनके लिए सीटिंग अगर रखी है तो पर्सन विद डिसेबिलिटी के साथ में उनकी केयर गिवर की मतलब 2 सीटिंग होनी चाहिए एंड दैट 2 शुड बी अवे फ्रॉम द क्राउडेड प्लेसेस भीड़ भड़के से दूर हो एक शांत जगह के अंदर में हो। अगर मैच डाउन होते हैं पर्सन विद ऑटिज्म के साथ में तो उनको हम लोग क्वाइट स्पेसेस प्रोवाइड करें तो ये प्रोविजन जो है पर्सन विद न्यूरो डाइवर्स पॉपुलेशन के लिए भी इसके अंदर में आनी चाहिए।
थैंक यू। Mallika Arjun ji.
Yes, Namaskar ma'am. Thank you very much for this opportunity. Maybe 3-4 points I would like to bring forth. सुगम्य भारत is the way forward for विश्वगुरु भारत. जिसे माननीय प्रधानमंत्री जी का मानना भी है. We have seen that it comes under the highest priority of Honorable Prime Minister of India. Most of the time he has indicated it. And if I look at intent, content and implementation with regards to accessibility, intent seems to be pretty high at the highest level, including the Prime Minister. Through the ministry, the content has been developed in terms of standards. Now the challenge is the implementation, which needs to be done. And this also needs to be done in Bharat. Urban areas still we can ensure a lot of activism is happening and things can happen. But 70% of the persons with disabilities reside in rural areas. And we also need to take care of the standards and guidelines in the rural context as Indumati has talked about. So I have few suggestions. One, at the highest level, there should be interministerial high-powered committees to coordinate it. And as my colleague suggested, DEPwD, MSC, should lead rather than anybody else to ensure to keep the spirit or the essence intact.
Could you come closer to the mic, please? I think the interpreter is having difficulty hearing. Thanks.
Oh, I'm so sorry. Is it fine now?
Yeah, it's fine now. Thanks.
So the first suggestion that I'm giving is to set up an interministerial high-powered committee under the chairmanship of DEPwD Meeting. The implementation is in the right direction.
Excuse me, sir. Can you speak more louder?
I'm using microphone. Yeah. Am I audible now?
Closer to your mic, please.
Yeah.
No, sir.
Not it?
I think there are some people who have their mics on, ask them to switch off their mics.
Oh. So maybe you can take somebody else, ma'am. In the meantime, I'll try to figure it out.
Yes. We can move on to Dr. Smriti now. After Dr. Smriti, Shashank Pandeyji, then Subhash Vashishtji.
Good evening, ma'am. Good evening. Good evening, ma'am. Am I audible to everyone?
Very audible. Dr. Smriti, please go on.
Yeah. There are 2-3 points I would like to make, ma'am. I made my presentation, but I guess I'll not have my time to present myself. We think of accessibility issues, and many a times we do such a job that we can't imagine. Like putting up braille thing on the bus stop where nobody knows where it is, what is the name of the bus stop. Instead of that, if we would have bus announcing system, something like that, that would have been better. Buildings we talk about ramp and everything, but where are we for that? If we can put voice sensory things, so visually challenged person can also know that whether they have entered in the right building. My most important point is, ma'am, whatever policy we make, we are not gender sensitive towards whatever policy we are making for disabled. We make disabled friendly toilet, but I don't know, till date I have not seen toilet for disabled women, which should be there, like as simple as this. Another important point, ma'am, I would like to make that healthcare system, which is the basis of everything, which decide disability, but which is most inaccessible for everyone, for disabled and especially for disabled women. It is very difficult. Like I have been advocating about QR code on the medicine. I have been talking about, so medicine should be identifiable by disabled people. And then I have been talking about e-prescription by doctors, which is very simple nowadays. So disabled people or hearing impaired people can identify instruction or whatever is written in the prescription by themselves. This is what I wanted to tell, ma'am. Thank you so much. Here I am representing Cure India today.
Dr. Smriti. Shashank Pandeyji, then Subhash Vashisht, and then D.G. Bhartiji.
Hello, ma'am. Am I audible, right?
Yes, you are.
Okay, ma'am. And I have 3 major points to make. First point being derived from the Supreme Court judgment itself, that while formulating the rules, we have to differentiate between accessibility and reasonable accommodation, because Supreme Court has very categorically stated that accessibility has to exist from get-go. So the mandatory fundamentals that we are determining will be a part of reasonable accommodation and doesn't necessarily will be in the case of reasonable accommodation. So formulating policy while formulating rules. Yeah.
1 second, Asif, could you just mute yourself, please? Your screen reader is coming into the meeting. Thanks. Yeah, continue.
Yes. So the point I was making, that accessibility and reasonable accommodation has to be differentiated. That yes, rules will provide accessibility, but they should also provide the individualistic reasonable accommodation scope that will be required, and this is something that should be made clear with the appropriate government and the private bodies itself, that there is a categoric differentiation that exists. Second point that we saw with the existing rules was that often when the conflict existed in some form wherein multiple ministries or multiple departments were involved, so it was very confusing which is going to be the nodal agency who is going to be responsible for the correction or enforcement of that rules. So that was also something that has to be pointed out. And a third thing is the Supreme Court has emphasized accessibility as a universal design. So I think we also have an opportunity to, while formulating accessibility guidelines for PWDs, we should also consider other communities that Supreme Court itself mentioned will benefit from accessible mandate, because that will be sort of an example of how accessibility should be ensured universally. And the last point being that, which is again on the legislative side, that we have to have Section 89 and 90 amended, especially Section 90, because violation by companies right now doesn't prescribe any monetary, fines bracket. So that's something, a legislative lacuna that we are suffering from, and will be very beneficial if we have that. Yeah.
Thank you. Our next speaker is Subhash Vashishji.
Thank you, ma'am. Am I audible?
Yes, you are.
Yeah. Thank you. I represent Center for Accessibility in Built Environment, and I've been contributing to these standards, for almost more than a decade. Ma'am, when we started, the whole process of harmonization of standards was started in 2010, and the objective was that there were so many standards that existed, and we wanted one nation, one standard. And what we have today is that we have created another mess, because the idea was that we centralize different ministries, but in this process, each ministry started creating their own standards which were differing with each other, and that was a huge lacuna that wasn't intended in the beginning. Idea was to have, but today, as we stand, the solution that we need to have in Rule 15 is for two areas, ICT and built environment. I think the nation need to have one standard, and each ministry can supplement their sectoral issues that could also come into this, where these ministries could sort of supplement these. For instance, I give you an example. For instance, making a temple accessible. Now, there are sectoral issues of temple or a religious place. For instance, there might be a wuzu, there might be keeping a specific section of prayers. These specific sectoral issues can always be clubbed in from relevant ministries, of course, in one common repository, rather than having 100 different guidelines. So that's my very strong suggestion. Instead of, we need to really do away with so many guidelines, and I was really surprised. The last two guidelines that have been issued are actually, they're adopting the harmonized guideline and the IS 17802. This is, is each ministry required to adopt these guidelines, or are they not mandatory on all of them? Are they even required to do this? The idea was that we need to have sectoral standards supplementing the main guidelines. So this is a huge confusion that we need to somehow remove in this process. Second major issue that I want to bring is, it is not happening despite the existing guidelines, because there is no training at the state level. Absolutely no mechanism, whether it is a bus standard or is a building or the website or a very small product. There is absolutely nothing in the state which compels people to abide by it. They say it doesn't exist in our laws. So it has to reflect into state laws, regulations, and I don't know how it's to be done, whether it's a checklist or each state is made mandatory. Third is the important issue is any funding that the government is giving. There are so many schemes under which government funds buildings, government funds various projects, and a lot of ministries fund these projects. These projects should not be issued if the money, the building or the product, or they are not accessible. So this is something we have to integrate from there, where the funding also happens. Reasonable accommodation, I think my earlier speaker has already indicated that I feel that this need to be also included into the rule itself as a part of standard itself, that these reasonable accommodations for different disabilities a list of tentative list can always be included in each standard, and each ministry or each department can always supplement to these. So I think I'll just close it here. Thank you for this opportunity, ma'am.
Thank you so much. Mr. D.G. Bharti, then we take D. Manocha, and then Arman Ali.
Thank you, ma'am. The basic issue I want to raise is how it is implemented is a big issue, because making guidelines is the easiest thing, but how it is implemented, how it is measured, how it is verified is a big issue. Because I will give two examples. One is that 5 years back we met RBI in Chennai regional center. So they said all the banks are called and they said we have problem with rented buildings. Others are common building, but they said that we have problem, so we will give them alternative. But the alternative was they will, whenever the disabled is called, we will go there to the home and then they do the service. But it has never been implemented. So second thing is recently held this para sports swimming competition where I was also a participant. There was no measurement was taken. They were kept in hot sun. Everyone was resting. And these are the very common things because the guidelines are given, but they are not implemented properly. Even the ramps are given. After 2020, everywhere ramps are made, but access to ramp is a problem. So like that, so issues are very, very minute. So, but they are very crucial. I cannot climb in the ramp unless I get pathway to access the ramp. So this is in metro, in the bank, ATM, everywhere this is a problem. So these problems should be identified only based on the verification by the user. The beneficiary should be good. So this seems very properly. Thank you.
Thank you. D. Manocha, Arman Ali, and then Mr. Kunal.
Thank you, ma'am. So, I just wanted to raise one point here that this particular meeting and this thing is, I think, about defining what is going to be made mandatory in terms of the standards which have already been issued, whether those standards are capable of being considered as bare minimum that have to be implemented and made mandatory, or are there some subsets of it which should be made mandatory and rest to be kept mandatory in voluntary kind of system. But I think the example that I can see is the IS 17802, which was notified and which was created as a Bureau of Indian Standards on ICT accessibility, and what the sector and what we as people with disabilities who have participated in creating these standards feel that this standard actually should be taken up as is, as a minimum standard to be made mandatory, and we can actually do some kind of a review of these things, that how can some further clarifications be given in addition to these standards to be made, meet this criteria of made mandatory. For example, even today the IS 17802 does not mention that all textbooks of the boards, the digital versions, should be in EPUB format complying to accessibility standards, the EPUB accessibility standards. So these kind of further clarifications, I guess, can be added, and we obviously will need to find a place how such kind of further clarifications or further specifications can be added to existing standards and brought under the regime of the rules of the PWD Act. The last point which I want to make is that I guess we will need to work in subgroups, sector-wise subgroups, to assess such standards. Like what I can actually see and the kind of expertise that I can provide on ICT standards. Similarly, there are going to be other sectors and other people who can provide their expertise on those fields. And if we can actually create such subgroups to work on the existing standards and guidelines and chalk out which are the mandatory ones which can be implemented as of now today and made mandatory. Thank you.
Hi, good afternoon, ma'am. Am I audible?
Yes, you are.
So I would first like to put in record the huge task that the DEPwD has in its hand, and ma'am, this is a time that we will change an era. On behalf of everybody, those who are else who are not, we are all with you on this. And there's a galaxy of people who have all the expertise to bring in this change. Ma'am, I'm very keen to know, and all of us would be keen to know the process that we adopt to take this further, to decide on the non-negotiables and beyond. And let's plan for the next 50 to 60 years. And all the points that has been said by everybody is very, very relevant, and that it's a huge task at your hands, and you are not alone in this. So I want to put this on record that we are all with the department to work together with you so that we can take all the relevant ministry, the private sector, the election commission, and everybody else in this, that nobody else can ever ignore disability from henceforth. That's all. Thank you so much, ma'am.
Yes. Good afternoon, ma'am. And thank you for giving me the opportunity to speak on this. I will support Manusha sir's point that the expert group who are expert in particular field should be also consulted in this, who have been working in this field. Because we actually, like ICT or content accessibility as per section 42 of RPWD Act, we have been working in this field from 2018-2017. We exactly know that what is the problem. We will put our points. Let others also put our points. Because recently, ma'am, you might be aware that the theatre accessibility guideline was issued. But there are so many loopholes which has been left in that today, if you see, post the implementation of guidelines, on 5th December, you have a movie which is coming, Pushpa 2. And we realize that prior to this guideline, at least all the theatre in India was accessible for visually impaired. Visually impaired could walk in any theatre and listen to the audio description if it was available on any app. I'm not saying my app, any app, which was working in all the theatres. But today, the situation is such, application which is working in 10 theatres is being allowed. And how it is being managed? What is the loophole has been left? Who is being responsible? When we question this, then everyone who is there every organization whose name is there, they say this is not my responsibility to check whether it is working in other theatre or not. So these kind of a loophole should not be left so that the people are getting disturbed. Solutions has to be universally designed. So the principle and the guideline, the principle of universal design should be followed in toto. Today, people are expecting that the closed captioning you read on the second screen on the mobile, how many people are comfortable to read a closed captioning on the mobile and see two screens at one time? Is there any survey? No, but this is just made as a solution that, okay, we are providing you on the mobile, you watch the closed captioning. Our application provides it, but still, we are not ready to provide this solution. We are saying that this is not the app solution. Because if you speak to someone who cannot listen, the deaf community, it's a problem for them. But there is no way to address. And it has been, the grievance mechanism should be so tight and the penalty should be so tight on all these organizations that they do not actually try to take advantage of any loophole, and we will have to keep up with them. Because like any other rule, we understand that if a rule is made, people try to break it. So automatically there should be a very quick method to seal that gap. Because obviously, I agree that the day one, we cannot make everything right. But yes, the guidelines should be strict, watertight, and this kind of a technical information and knowledge should go inside it while drafting it. So I would humbly submit that we are up for giving any support to the department, that whatever is required at any level to make them give our viewpoint, and all the loopholes if has to be sealed up from the day one. But whatever is left should be a progressive, and improvement should come up in following updates. Thank you, ma'am.
you. I can safely say that we are now on our last three speakers. We will give the mic to Mr. Ashutosh Singhal, followed by Shishu Sirothi and Mr. Akhil Paul.
Good evening, ma'am. I hope I am audible. My first point is like a penalty should be percentage wise, like according to company net worth. If you will put 10,000 fine on the startup, it will be good punishment. But if you will put same amount on penalty on Google, Microsoft, LinkedIn, Spotify, or any other company, big companies, it will be not good because that is nothing in front of their capacity. Second point, guidelines should be also applicable on NGO because it is applicable on government as well as private, right? But NGO, non-governmental organization, is not government. I believe it is also not private. Third point, there should be strict punishment on the government auditor. The Department of Empowerment of Persons with Disabilities made so many acts, like Sugamya Bharat app, but that is also inaccessible. Saksham for election, that is inaccessible. And one app, one website also for Skill India, I am not able to remember, that is also inaccessible. So government auditors also should punish properly. I hope I made some sense. Thank you.
Thank you. Who's the next speaker? Mr. Akhil Paul?
Yes, ma'am. Thank you very much. And all my colleagues from the sector have made some very valid and good points. I have 3 points, ma'am. One is on the universal design principles. I propose that it should be inclusive planning when we do that. When I say inclusive planning, spaces, we have talked about buildings and everything. We need not forget the services, particularly healthcare and education, which requires a lot of support and a lot of monitoring as well, making it accessible to all. And when I say all with physical, sensory, cognitive disabilities, we need not do a special modification later if we do it. And because I work with deafblind people, I would propose adding the tactile communication and interpreter support, human interpreter support, which is required. Second, on the assistive technology integration, on digital accessibility, I think we need to have features. Dipendra Bhai and others have already talked about websites, mobile apps, public information systems, WCAG, all that is fine, but making it inclusive, procurement a necessity. I think if all government procurement prioritize assistive technologies, then we will set a standard for private adoption as well. So if we start with the government, it will be useful, ma'am. Third, comprehensive inclusion across disabilities. So having disability-specific solutions to address unique needs of diverse disabilities. I've spoken about deafblind, so sign language and tactile sign language interpreters for deafblind and captioning for deaf individuals with hearing impairment. We talked about audio navigation and cognitive accessibility guidelines for people with intellectual disabilities. I think Dr. Smriti was mentioning something about it, but that's very, very important. And the most important thing, I feel that intersectionality, ma'am, in accessibility, the factors which overlap in terms of the barriers due to gender, caste, rural and urban divide, the economic disparities. So if we, in our sort of guidelines, if we say that we deploy targeted intervention in underdeveloped regions, that will help us gain that balance. And as civil society, we are all with you, ma'am. Thank you very much for the opportunity.
Thank you. Next is Ms. Shishu Saroti, and then we will hear Vaishnavi Jayakumar, please. Saroti, are you going to speak? While we wait for Shishu, I think Vaishnavi, why don't you take the stage? Vaishnavi Jaya Kumar, please.
Yeah. Hi. Good evening. Firstly, we had sent a representation signed by more than 150 people across India regarding this process and a few things which needed to be done in parallel along with it. I'll also send it to you since you are, kind of driving this initiative. So I'm not going to repeat myself on that front, but there are three things that we need the DEPwD to do, which were not mentioned in that representation. And one is there was a monitoring website of the AIC, which had all the states giving inputs on buildings which were being, kind of accessified, or buses which were, details about the buses, etc. And that website, though it was brought in 2019, seems to have gone offline. We'd like that restored, please, and updated, on an ongoing basis, because that way we have some record of, what the states are submitting, and that way we can call out the states on that front if they're reporting erroneously. Secondly, the earlier AIC access audit reports were removed from the department's website ostensibly because it was slowing the website down. We understand that. Perhaps you could have a separate, kind of online library elsewhere, because otherwise we're finding that the same places are being, kind of proposed for auditing time and again, and that's a complete waste. Thirdly, the Sugamya Bharat app. And while I mean, I think that we should really be focusing on new infrastructure as of now, and the retrofitting can, kind of come a little later, because it is a tremendous exercise which will exhaust everyone. But while that is happening, I think it's important that we use this time and as a kind of awareness, so that other ministries and other departments are kind of aware of their obligations. And to that end, if the Sugamya Bharat app can be made public facing, we don't need to know who has made the complaint. That can be anonymized, but let people just start giving in inputs, and let the department start fixing those inputs using the Supreme Court order on a real-time basis. So at least let the retrofit be on demand. And there are some things which will be very easy. For example, yesterday we got a request about a building in Mumbai, which is a central government building, the fisheries building, which is inaccessible because the lifts are not working. Now that's something that the department can do very easily and pull people up, because there are disabled employees in that building who are struggling. So that's a small example of using the Sugamya Bharat app to, kind of keep other people on their toes and to troubleshoot on demand rather than the entire retrofitting of India, which is a huge task. Thanks.
Thank you. Is there anybody else who would like to speak and I have not managed to
Can you
call out?
hear me?
Yes,
Can you
we
hear
can
me?
hear you. Yes.
Sorry. I'm Ketaki Bordala, speaking on behalf of Shishu Sharathi, and we are also empaneled access auditors for the Accessible India campaign. My colleagues who manage the access audit also are constantly come up with this issue of the problem of the dilemma of enforcing accessibility in places where the geographical terrain is difficult, particularly in the northeast region. We work in Assam, and we have done access audits in different states of the region, and states like Mizoram and Meghalaya, Nagaland, for instance, where most buildings are extremely inaccessible. If, as you go forward, when these universally designed buildings or physical spaces are being considered, the issue of geographical terrain is also factored in. It would be a huge help. Thank you.
Anybody else who would like to speak? Otherwise, we have come to the end
Can I
of this.
speak, Madam? Nandare?
Yes, please.
Madam, I am a wheelchair-bound person, and I wanted to make one point. The hospitals to be made accessible. All that they do is to provide ramps at the entrance and the steps. But what makes hospital different? When you go to hospital, you have to undergo various tests like MRI, X-ray, sonography, and examination table. All these are at a height. For a wheelchair-bound person, it becomes very difficult to get transferred from the wheelchair to be stable. So what I said, in order to make hospitals accessible, you should have a wheelchair whose height can be adjusted from 20 inches to 30 inches so that he can be transferred from the wheelchair to the MRI table, X-ray table, sonography table, X-ray table, so that life becomes very easy. Otherwise, when I visit hospitals, I find it difficult that every time I have to be lifted and transferred to that table. Then something can be made to, a wheelchair can be arranged in a hospital whose height can be varied so that that man need not be lifted and he will be taken for any test in the hospital. So this is what I think we should be done to make hospitals accessible in India. Thank you.
Thank you. I think there's one more speaker. Pradeep Raj, would you like to speak? Anybody else whom I've missed inadvertently? Yes, Professor Sanjay Jain. 1 point again. Yes, please.
Just half a minute. I think we would miss the bus if we don't thank Center for Disability Studies for having brought out such a brilliant report. Because that report has shown us the mirror about our accessibility record. And I think whatever we want to do, we should use that report as a resource. And I personally pay highest tribute to Professor Dhanda for, enlivening an issue which was almost become dormant in the government records. Thank you.
Yeah.
Thank you.
Can I speak, ma'am? This is Asif.
Yes,
my name is Asif. I work for PwC. I'm also a blind individual. Ma'am, in the era of startup and especially in m-commerce, and when the government is very keen on focused on ease of living, ma'am, I really strongly feel that we should have non-negotiable criteria when they start up. They start some kind of services, especially on the m-com or mobile commerce, that at least they should follow the principle of universal design and digital accessibility, and this should definitely be considered as non-negotiable. Let's say in today's age, if I wanted to order medicine, sadly I couldn't do that. There are so many startups, even the prominent and renowned one, but this cannot be done. And as Dipender sir pointed out, that we have ICT standards, and I was also privileged to contribute to that. We should at least have one harmonized guidelines as far as digital platform and digital commerce is concerned, which should be definitely on a non-negotiable list. Thank you. Over to you, ma'am.
Thank you. So I'm just quickly summarizing. I will not get into very detail.
Can I say one sentence?
Yes, please.
I just wanted to ask one thing. We have a network which is discussing this. After how many days do you give us to send our responses?
I would be grateful if it comes as soon as possible, and maybe you can take another 3-4 days, 5 days. Is that workable?
Okay. Yeah, 5 days is fine. Because I work on disasters and climate change, and we have very specific issues, and also the Network of Women with Disabilities would like to send in something. Thank you so much.
Thank you. I have also shared my email ID in the chat box. I will read it out once again for everyone. It's manmeet@ias.nic.gov. We have received a lot of very enriching insights and a lot of inputs that one can go in. It is definitely very clear that there is a requirement for basic, non-negotiable, mandatory provisions, which is cutting across physical infrastructure and public spaces that may come under the purview of many, many departments. But as long as they are visited by the public, the common people, and people with disabilities, they all need to have these basic requirements. We have also spoken about born accessible, as in anything that is new, it is completely has to be of a universal design and norm, taking into requirements of people with disabilities and across disabilities, and new infrastructure, everything has to be born accessible, of course, unless there are certain relevant sectoral guidelines themselves that would require it to be so. A very important aspect of all these guidelines / rules or standards lies on the enforcement machinery that needs to be strong and strict, whether it is withholding of any kind of clearances or NOCs for physical or digital infrastructure, and with strict penalties that are quickly given and also taken up before that change is also initiated and that change is required to be done. Of course, the work on retrofitting and the work on evolving guidelines should continue. The work on interacting with different stakeholders like the one we did today, and also stakeholders that belong to the private sector, for people with disabilities, with caregivers, with organizations that work with people with disabilities, with advocacy groups, with advocates and lawyers, needs to be a continuous affair, and it should be done regularly. The aspect of having apps or websites which help in giving out information and to make it available to the public has been noted. I will find out the reason of why it was stopped.